The proceeding will start shortly. 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 The proceeding will start shortly.
Order, order. Steve McCabe to move the motion.
Good morning, Mr. Bowen. It's nice to be back and a pleasure to see you in the chair. Can I also take this opportunity to welcome the Minister to her post. Mr. Bowen, I want to raise today an issue which has the potential to become a serious immigration problem, but one which there is still plenty of time to avoid. The EU settlement scheme is the largest registration programme the UK has ever known and poses the challenges of regularising the status of around 3.7 million people, including about 700,000 children, 74,000 of whom live in the West Midlands. The quarterly EU settlement scheme statistics show that only 12% of applications to the scheme received by the end of June 2019 came from children under 16. I'm sure we all want to prevent vulnerable children from falling foul of problems associated with these plans as we prepare to leave the EU. I believe there is significant cross-party support in both houses for this issue, and I hope today the Minister can provide some reassurance. The Government has estimated that there are about 5,000 EU children currently in the British care system and perhaps a further 4,000 care leavers across the UK. We don't know the exact figure because local authorities don't record that information, Mr Bowen, so I am relying on government estimates. The figure doesn't include children classified as in need and therefore in receipt of considerable support from children's services, but where the department has not assumed parental rights. The Minister will be aware, I'm sure, that the distinction between a child in need and a child, and therefore in informal care, and a child in the formal system is quite a fine distinction. It really relies on the point at which intervention is required. Therefore, I would submit that all of these children need to be registered. If previous registration is anything to judge by, it seems impossible to believe that 100% registration can ever be achieved. If just 15% of children are not properly registered, we may find ourselves doubling the number of undocumented children in this country. Recent pilot exercises suggest there will be significant problems for local authorities in obtaining critical documentation, such as birth certificates. I'll give way to my honourable friend.
He's making a very strong case on why we need to address this very issue. I speak as an MP for one of those pilot areas in Waltham Forest, and one of the simple challenges was getting hold of documentation, because embassies won't release documentation to a child, they'll release it to a parent. And of course, if children are in care, then that relationship with their parent is strained. Does he therefore agree with me that this means we need a specific scheme and a way of dealing with children in care who are EU citizens if Brexit is to go ahead?
Well, I entirely agree with the points my honourable friend has raised, and indeed that is part of the purpose of calling this debate, because I don't think the scheme as currently designed is going to cope with these difficulties. As she rightly says, the pilots demonstrated the difficulties of obtaining documentation, particularly birth certificates, which the Home Office put a very high premium on when determining these cases. And I'm concerned that many children and young people, like my honourable friend, I'm concerned they won't be able to access these documents. And as a result, they'll be wrongly denied settlement status. Now, I'm aware that the Minister's predecessor did indicate that the Home Office planned to show a degree of leniency in this respect. But unfortunately, she didn't spell out what she had in mind. I don't know if the Minister will be in a position to enlighten us today. No doubt she'll tell us that in these cases, these children will be eligible for pre-settlement status. But what that actually means is they'll get temporary rights and be denied their legitimate legal rights, and that's why it's a problem, and that's why we're raising it, Mr Bowen. As members of Parliament, we have a duty to ensure that the most vulnerable in our communities are protected, and that children for whom the state is responsible receive the highest levels of protection. It seems to me that, as well as the documentation issue, there are several challenges with these proposals. It's extremely doubtful that social workers will have the time, the expertise or the legal knowledge to register these children. I give way to my honourable friend.
I congratulate my honourable friend for securing this debate, but his comments actually raise a number of questions. First of all, the final status of these children, ultimately, because we've had problems in that area before, but more importantly, through a lack of social workers, it's always going to be difficult for local authorities to actually get the accurate documentation that's needed. And this has been raised many, many times in the House about a lack of social workers and lack of funding for local authorities. I don't think it's about time central government showed a bit of humanity there and did something about it.
Well, I thank my honourable friend for those remarks. I hope in the course of the debate it will be possible to demonstrate that this isn't scaremongering. These are real issues and that there are solutions, but it does require the government to recognise the kind of problems my honourable friend has raised and to agree to act on them. As I say, it seems to me unlikely that social workers will have the time, expertise or legal knowledge to deal with these issues, particularly if they begin to encounter problems in the process. The Children's Society, along with other charities, have repeatedly highlighted the problems that this group of children are facing and the challenges that exist in trying to process an EU SS application. There's no evidence that I'm aware of that additional support is going to be made available to local authorities, point my honourable friend raises. During the pilot phase, every application the Quorum Children's Legal Centre made on behalf of a child in care or a care leaver included detailed nationality advice that requires expert legal advice and understanding, and that social workers had to be supported at each stage during the process. That's the evidence from the pilots. Happily.
I congratulate him on the case he's making. The Greater Manchester Immigration Advice Unit has been working with directors of children's services in Greater Manchester to try to offer that support. But does he agree with me that we urgently need the government to get the resolution that's currently before the House in relation to extending legal aid to children in immigration cases through the House and onto the statute book, so that social workers are absolutely clear that legal aid is available for these cases and that they won't just have to rely on the chances of exceptional case funding?
Well, my understanding is this is an outstanding government promise. As my honourable friend says, there is a resolution to that effect. If there are any plans to curtail the time we're going to spend here in the coming days, one good use of the time here would be to deal with this simple issue, Mr. Bone. It would certainly raise the prospects that we would be able to deal with this whole issue in a much more satisfactory manner. I would certainly support that. As I understand it, the current guidance states that local authorities can make applications on behalf of children where they have full parental responsibility. But for care leavers or children in care under a Section 20 order, the point I was making earlier, they are instructed to simply raise awareness or signpost these young people to the scheme. Children in care under Section 20 orders include children with disabilities, children who may well be the children of prisoners, children who are involved in the criminal justice system, and of course children who are victims of child trafficking. It seems to me quite unrealistic to think that these children will be able to gather the correct documentation make the application for themselves and challenge any incorrect decision that the Home Office may arrive at. Looked after children are starkly, as I'm sure the Minister knows, overrepresented in the criminal justice system. Around half of children currently in custody in England and Wales have been in care at some point. There's absolutely no clarity, as I understand it from the government, about how these children will be treated when they apply for the scheme, and if they are offending, as in the adult scheme, will be used against them. Now, obviously, we normally take the view in this country that criminal behaviour by juveniles is treated differently from that of adults, hence the point in raising this, Mr. Bowen. Many looked after children and care leavers may actually be eligible for British citizenship, but the social worker will require a knowledge of the law to recognise this, and it would mean that local authorities have to pay the application fee, currently £1,012 per child. Mr. Bowen, that's a significant disincentive for cash-strapped local authorities. As I said earlier, Mr. Bowen, we're working on estimates because local authorities do not record EU nationals who are in their care or classed as children in need. But, as I've said, the government estimates there are about 5,000 EU children currently in care and perhaps a further 4,000 care leavers across the UK that need to be registered. And, of course, children in need, that wider group that I referred to, account for an additional number, but a number that it's virtually impossible to estimate at the present time.
Thank you, friend, for giving way. He raises the very important issue about citizenship fees, and I hope the Minister's already seen the fantastic work that Citizens UK and indeed, in particular, Anne-Marie Canning, who's a Walthamstow constituent, and we deal very closely with a lot of these children. One of the things that worries me about all of this is having your documentation also opens doors for some of these young people. And if we have done the right thing as corporate parents and helped these children achieve and helped perhaps deal with some of the damage that has led to them being in care, watching children, for example, be denied the ability to go to university, be denied the ability to go to further education colleges because they can't sort out their status, will be a horrific blow to some of the most vulnerable children in our country. Does he then, again, agree with me that we've got to make sure this isn't just about their status, this is also about their future, and that's why it's so important the government recognises this particular group of vulnerable young people needs a specific scheme?
Yeah, that's absolutely the point, Mr. Bowen. If we don't try and get on and deal with this now, there's going to be a whole host of young people wandering around this country, sleeping on streets, unable to get accommodation, unable to get jobs, unable to travel. That's what we're going to be subjecting them to for the next few years. That's why it's important that we get on top of this and deal with it now. I checked with Birmingham Children's Trust before this debate, and I understand that they have around 50 children who they believe to be EU citizens and who will need to apply for some kind of settled status. And they have about 24 care leavers who they think also fall into this category. But at this point, the Trust has not yet made any applications, and they weren't entirely clear about how the process should operate. I mean, this is the second largest local city in the country. I mean, if they are not quite sure how to operate this scheme, what on earth is going to happen elsewhere, Mr. Bowen? And as my honourable friend was indicating, there are all these future problems, but there will be some very simple problems for children in the care system in the months ahead. Will they be able to go on school trips abroad after the 31st of October with their peers, or will they actually be stigmatised in some way and refuse that because they won't have access to proper travel rights? and what will happen to them, as my honourable friend rightly says, when they're seeking housing, benefits, other support, they will be denied this support. Mr Bone, we see enough problems on our streets at the present time. We certainly don't need to add to that by ignoring children for where we have taken responsibility for their care. That seems to me the worst possible thing that any group of MPs could do. Now, I think the simplest and most cost-effective solution to these problems would be to grant automatic settled status to all looked-after children and care leavers. I don't think it's such a massive number that it would impose great strains on the immigration system, Mr Bone, but it would actually tidy up one very straightforward issue with one very straightforward group of children. At the very least, the government ought to extend the deadline for applying for the settled status scheme until we've really understood how some of these issues are going to operate in practice and what kind of problems are going to arise. If the Home Office are not willing to make changes of that order themselves, they need to instruct all local authorities to ensure that all eligible children and looked after children are supported to make an application, and not just children under a Section 31 care order, because if they're really serious about making this work, they wouldn't leave those children exposed to such risk. And I think, as my honourable friend indicated, the government need to urgently bring forward parliamentary time for the amendment allowing looked after children to have access to legal aid. It seems to me that's essential if there's to be any sincerity about this process. And they need to communicate to all local authorities exactly how this legal aid will be accessed, because it's not enough to place an obligation on the local authorities and then leave them with all the difficulties. We've seen that happen all too often in recent times. It's not good enough, Mr Bone. The Home Office should also consider waiving the fee for citizenship applications for those children who qualify. As I say, the current fee is £1,012. It's a disincentive to local authorities. If the children are eligible and they're already in care, we should simply agree to waive that fee. Mr Bone, I think this issue has all the signs of a disaster in the making. I can't honestly believe that of all the people we're concerned about, I'm here talking about children in the care system, children who we say we are going to look after and protect and give a better chance to in the future. But I think it does have all the makings of a disaster. I think it's a disaster that could be avoided. And if the Minister will agree today to meet with us, those of us who are working on this issue and the relevant organisations who have the knowledge and the advice, I think there's still time to stop this happening. Thank you.
The question is that this House has considered the EU settlement scheme and looked after children and care leavers. Tim Lawton.
Thank you very much, Mr Bone. It's a pleasure to be back and a pleasure to serve under your chairmanship in a subject that I fear might be slightly overshadowed by other events going on in Parliament today and this week, but is no less important in the impact it potentially will have on a small group of very vulnerable children. And it's absolutely right that we should be considering this. And I congratulate my co-applicant for this debate in the way he set out the case, and I'm grateful to the Backbench Business Committee for granting time on this first day back as well. And I very much welcome the new Minister, and I hope we will have as positive as engagement with her on these sorts of issues as we've had on her predecessors. And I certainly think some of the predecessors where I've had many discussions in the past have very much recognised some of the practical implications of immigration policy on some of the most vulnerable children that we provide home to in this country. And I'm sure that dialogue will continue, and I look forward to it. Because we do have, Mr Bone, in this country, a great tradition of looking after children in the care system. There has been gradual progress in improvements of outcomes, but we need to go an awful lot further. But it's something that we do well in this country, and one only has to go to a number of other countries where they just do not have the sort of sophisticated and advanced children's social care system which we take for granted, with all its problems that we hear about in this country, but it's still one of the best in the world. And of course we also have a great record, a proud record, in giving safe refuge to vulnerable families and children from overseas, particularly unaccompanied minors fleeing from the most unimaginable danger. And it's absolutely right that we should continue to do that, and certainly in our recent record on those very vulnerable children who have lost family from Syria and other conflict zones, and our participation in the family reunion schemes, which I'll allude to in a minute, I think something we should be very much proud of. And just to refer to the correspondence which the Home Affairs Select Committee has had with the previous Home Secretary, I don't think we take credit for this enough, but under the Dublin scheme, there has been a significant increase in recent years in the number of children arriving in the UK to be reunited with their families, members of the family already here. In 2015, the figures were just 24 children arrived in the UK under Articles 8.1 and 8.2 of the Dublin Regulation. But by 2018, last year, that figure had risen to 159. And it's important as well that we are looking after those children appropriately. So I was pleased to hear from the Home Secretary that the Home Office, in partnership with the Department for Education, has developed and adapted its processes to ensure that Dublin transfers are conducted in a safe and secure way. And there are new processes in place now which weren't there just a few years ago. Of course, I'll give way to the Honourable Lady.
I think one thing to make. He's right that Dublin has helped us support some of the most vulnerable children in our communities. Does he therefore share my grave concern about the reports that should a no-deal Brexit happen, that scheme will be abandoned, and what that means for the children that we already have here in this country, or indeed some of the vulnerable children we know may try to get safe passage to this country, and the importance, therefore, of protecting Dublin and the principles that it espouses in terms of our ability to safeguard children in our own country?
I appreciate that very important point, and that's been a subject of some of the discussions we've had with previous Home Secretaries about not only what happens if there's a no-deal scenario, but if there's an agreement, then the terms that should apply to children seeking to be united with families need to be at least as generous as Dublin, because under our own domestic terms, it doesn't include a whole range of other family members. So actually we need to overhaul our own laws and the flexibility with which we take on unaccompanied children seeking to be united with often distant, but the only remaining members of their family, such has been the danger and the terror that they've had to escape from. So whatever happens in the next few weeks and months, and goodness knows when, this needs to be looked at separately. And as I say, I've had very positive, and when I and the Culture Secretary, the Right Honourable Member for Loughborough, together have approached the Home Secretary before, having been on trips to Greece with UNICEF to see some of the children who are applying for these schemes. We've had a very positive response, and I very much hope that will be carried on under new ministers within the Home Office. But she makes a very pertinent point. So we need clarification under Dublin, whatever happens as well. But, Mr. Bone, there is a problem closer to home, which is what we're discussing today, as a direct result of Brexit, which hasn't received the level of attention that many other aspects of the immigration scheme have, and it is a cause for concern. And I have an interest in this both as a former children's minister, but chair of the All-Party Group for Children and vice chair of the All-Party Group for Looked After Children, which the Honourable Member for Selly Oak very admirably chairs, where these sort of issues come up with the children who we see within that group. Now, the EU Resettlement Registration Scheme aims, as we know, to establish the immigration status of EU citizens legally residing in the UK after we've left the EU. And it grants settled or pre-settled status with rights to work, travel, use public services and access public benefits and so on. And as the Honourable Member for Selly-Oak said, it is the largest registration system ever planned in the UK. It's been a huge challenge, not without its problems, certainly early on. It needs to progress smoothly to avoid another potential Windrush scandal, which has been mentioned. It has been subject to a lot of scrutiny and some criticism by the Home Affairs Select Committee, which I sit on, and we produced a report in May on the preparedness. In fact, we'll be taking evidence again tomorrow with the Honourable Lady for Stretford-Ermston there on how our preparedness for Brexit has hopefully progressed since we last had witnesses on this subject as well. Now over 1 million people have registered under that scheme. I gather nobody has been refused. I've actually had one complaint from constituents about the way it works. So I think things are better, still not ideal, but it is working better. And of course I do work.
I agree with him that there have been many people who've been able to access the scheme successfully, and it's been very helpful that the Home Office has begun to publish the data on the number of people going through the scheme. But does he agree with me that we do need one particular piece of data disentangled, and that is in relation to 16 to 18-year-olds going through the scheme? Currently, they are being included in the numbers of adults going through the scheme, but nowhere in our law is a 16 or 17-year-old treated as an adult.
The Honourable Lady is absolutely right. She preempts what I now won't bother to say later. But 16 and 17-year-olds have been assimilated into adults, and children in this country are those under the age of 18, and it's absolutely essential that that definition is applied to all children, not least those most vulnerable children. And as a result of schemes like Staying Put, then that effectively definition of those children who come within that remit will go up to ages 21, 23, 25 in case of children with disabilities and others. So those figures absolutely need to be disassembled so we can see, because these are actually probably the largest group within the cohort that we're talking about. Now, the Children's Society have been very vociferous on this, and they've done a lot of work on this, and I pay tribute to that, and they've helped us in the preparation of this debate. They've calculated, this is not about children in care, but just to put it into context, that between the end of August 2018 and the end of June of this year, 107,110 children under the age of 16 applied to the EU settlement scheme. Some 86% of them have had a conclusion to their application so far. 65% have got settled status, 65% have got pre-settled status. 180 applications were withdrawn or were void or were invalid. 0 have been refused. But that still leaves 14,500 to be concluded. So there is a group of children as well coming through the normal scheme who are slightly in limbo. Again, the whole point about the 16 and 17-year-olds, we don't know how this group is broken down. So I would repeat the Children's Society call to see the ages broken down further so that under 18s and 18 to 25-year-olds is another potentially vulnerable subset of children not of child age, but equally important and vulnerable, can be properly identified and therefore supported. Now, Children's Society also say that additionally only 12% of the applications to the EU settlement scheme have come from children under 16, but analysis from the Migration Observatory suggests that there were 700,000 EU children under 18 in the UK in 2018, meaning that hundreds of thousands of children may still need to apply for settled status or secure British citizenship, and if they do not, they risk being left behind without a lawful status in the UK, which means being unable to access education, employment, healthcare, housing, and other vital services. So actually, the problem is still quite a big one for those children in the care system and those other children who are not looked after, but at the moment are unaccounted for in the applications that have come through so far. So there's still an awful lot of work to do. Now, within that group, therefore, the looked after children, estimated up to around 5,000 who will need to apply to the EU settlement scheme. That figure doesn't include care leavers, As I say, some of them may be subject to staying put and other special support measures, or children classified as in need who are receiving support services and vital help from local authority children's services department. Now, that figure of just under 5,000 represents something like 6% of all the children in care in this country at the moment. 5 years ago, it was 3%. So this has been a rapidly increasing number, but an important part of the looked after children estate. And they are potentially some of the most problematic children to be able to identify, support and register. As the Honourable Member for Estelly Oakers mentioned, it is a sad fact of life that children in the care system are still much too disproportionately represented in the youth system, the youth justice system. Many are the victims of people traffickers. Many would have English as a second language, and many of them will rely on being able to access benefits and other support that we take for granted. And my concern is that at a time when our children's services departments are hugely understretched, and the All Party Children Group has produced a number of reports on this recently, and whilst I hugely welcome the announcement, which I hope we're going to have confirmed tomorrow, but goodness knows what's going to happen tomorrow, in the comprehensive spending review, about an additional £14 billion for schools, which will be very welcome, particularly in my part of the world, where Sussex and other Shire counties. I want to make sure we don't exclude children's social care services as well. They are the remit of the Department for Education, and they have seen some huge funding challenges. And yet these are the departments within local authorities who will be responsible for looking out for these children, who will be responsible for identifying them, who will be responsible for registering them, who will be responsible for having to summon on the legal expertise when those cases are not as straightforward as other children may be. And of course they're not going to be as straightforward as somebody who happens to be here with a French family, a German family, or whatever, where it can all be done on their behalf. Of course I will.
I thank my honourable friend for giving way. He's making a fantastic and very well-informed speech. He talks about the 14 billion going to education. 2 billion of that is due to go to Scotland. But as he'll be aware, Scotland is also devolved when it comes to matters of education. And one concern I have, and certainly I hope the Minister will be able to clarify in her closing speech, is how central government will work with devolved and local governments to make sure no EU citizens, and certainly that no one and no child in care is left behind. Scotland only has about 8% of the UK population, but we have about 14% of the UK population of children in care. It is a problem for us, and it's one that every single level of government needs to work together to make sure we're delivered and no one is left behind.
Well, my friend makes a very important point, and though we're primarily talking about England and Wales for the looked after children population, there is a particular issue in Scotland, and I hadn't realised that proportion was as high in Scotland as he mentioned. So it is really important that money that goes into education, which is for the wider benefit of children in the social care system there as well, is absolutely targeted to those children who need it most. And potentially, therefore, the problem in Scotland, if this issue is not dealt with, could be greater even than it is in England and Wales. So he makes a very important point, and I hope that the Minister and also people within the Scottish administration are listening to the case that he's made. Now, this is potentially the most problematic group of children. If they have come here in difficult circumstances, as many of them will have done, and gone into care, it is highly likely they may lack birth certificates, may not have passports, will find it difficult to prove their length of stay in the UK, and in any case may have been moved around, as so often happens, the whole system. And yet these children are expected to be able to produce the documentation in order for them to qualify under this scheme, documentation that may just not be there. So local authorities who are responsible for these children could face some huge challenges and detective work requiring buying in legal expertise and acting as advocates. at a time when they are hard-pressed looking after a recent record in the number of children we have in the care system of those from the indigenous population alone. And then added to that, and my honourable friend again preempted what I was going to say about the citizenship fees, and this is something that we have flagged up within the Home Affairs Select Committee in the past. The increase in citizenship fees at all levels has been extravagant, to put it mildly, over recent years, and it goes well beyond the cost of recovery of the service that is offered. And it was always the principle in the past that the cost of recovery should be equivalent to the charge, not that the cost of recovery should be exceeded in order to subsidise services elsewhere within the Home Office. And when you are looking at a figure of £1,012 for a child for whom we have given safety and refuge here, then I think it is very difficult to justify such a high fee, which will come out of local authority budgets in most cases, which will therefore come out of the children's social care budgets, which are already greatly pressed in local authorities, which means less money to spend on social workers and care placings for other children within their care. And at that point, I should have mentioned the past to declare my interest in the register as well, just to get that on the record, Mr. Bone. Just briefly, before I conclude with the ask to reinforce what the Honourable Member for Selyoak has already said, the situation about children coming over from France as well. There's been, again, recent correspondence between the previous Home Secretary and the Home Affairs Select Committee, because we were concerned about what was happening to children in some of the camps, very vulnerable in very dangerous situations in France, particularly those who did have a claim to come to the UK through the family reunion scheme and other schemes, but it seemed to be taking an interminably long time. And part of the reason for that, as I found when I went to Greece, is that potential candidates were being lined up by charities and authorities in Greece, but it relies on social workers back in the UK to do the investigative work to make sure their welfare is properly taken care of in the placements they were going to have when they came back to the UK. And the position of social worker recruitment at the moment is such that social workers are being pulled in all directions. But there was some degree of reassurance from the Home Secretary, who said in his letter, "I'm pleased to confirm that the vast majority of the cases involving children in France awaiting transfer to the UK have been resolved, with many of the children having already transferred under either the Dublin III regulations or Section 67 of the Immigration Act 2016, or shortly about to, and others are pursuing their asylum claims in France." These are some of the most vulnerable children, and frankly, if those children were in camps outside Dover, our local authority, Children's Services Department, and our government would have taken care of them. And it's extraordinary that this has not happened in other countries, and I'm pleased that we've now accelerated that process to make sure that they are brought to a place of safety where they qualify, as some of them do. So, in conclusion, Mr. Bone, there are two asks really out of this debate. Firstly, to grant automatic settled status to all looked after children and care leavers. I mean, the very fact that they are being looked after by local authorities, recognised as legitimate placements, paid for by the United Kingdom taxpayer and local council taxpayers, is an endorsement of their legitimacy in being here and our responsibility to look after in the first place. So surely the assumption should be that absolutely they have a place rightfully in this country, and if there's some problem with that, we should argue the toss later on, but let's give them that protection at the outset. And secondly, this whole issue of fees needs to be looked at, and certainly it was an ask of the Home Affairs Select Committee to the previous Immigration Minister. It is such a complicated system, as the Windrush Immigration Minister. It is such a complicated system, as the Windrush issue threw up. How many different avenues there are to get it, and with it needs to be simplified and reduce the charges for the whole system. The complicated nature of the system makes it a very expensive system as well. So, for goodness sake, for this small group, but most vulnerable group of children, I would urge the government to waive the fees for citizenship applications for those looked after children and care leavers. That is essential, I think, whether we have a deal coming out of the EU, whether we don't have a deal coming out of the EU, because frankly it matters not a jot to those children. They are the ones who need our help, they are the ones who need the support, they are the ones for whom this country has recognised that need and have provided support. So for goodness sake, let's not let bureaucracy stand in the way of continuing to do the right thing by those children, as we have a proud record of doing.
It might be useful for the House to know that the wind-ups will have to start no later than 12:30, and I have two members trying to catch my eye, so perhaps they could bear that in mind. Kate Green.
Much indeed, Mr. Bone. I'm very grateful for the chance to contribute, and it's a pleasure to speak under your chairmanship. May I also welcome the Minister to her post and congratulate my honourable friend, the member for Selly Oak, on bringing this debate forward today. I very much share the concerns that have been expressed around the House. In the North West, it's estimated that there are around 700 looked after children of EEA or Swiss nationality, but of course we don't know the numbers for sure, and it is vital that we gather the data, and so I was very pleased to see in a written answer to Lord Russell on the 9th of July that the Home Office will be surveying local authorities to benchmark the current uptake of the scheme and to baseline cohorts of EEA citizen looked after children and care leavers. And that this survey will take place at set intervals throughout the lifetime of the European Union Settled Status Scheme. I wonder if the Minister will be able to update us on the progress of gathering that survey data, if she can confirm that it will include children in need, a vulnerable group not apparently encompassed by the provisions of the Settled Status Scheme and special help from local authorities, as my honourable friend pointed out, and if she can also confirm that there will be the opportunity to disentangle data from the statistics in relation to 16 and 17-year-olds. As others have said, we are talking about the most vulnerable children in the country who may have suffered the most appalling abuse or neglect. And securing status for those children, as we've also heard, is absolutely vital for them to thrive and to maximise their potential in adult life. I share the concerns that have been expressed about local authorities being only required to ensure that applications are being made for children looked under Section 31 care orders. I invite the Minister to explain to the House why other children looked after under or in the ambit of Section 20, or those, for example, who are privately fostered or care leavers, for that matter, are not also included within this obligation on local authorities, because these too are very, very vulnerable young people and children. The Government has obviously intended the application process for settled status to be straightforward and simple, but as we've heard, that won't be the case for many looked after children because of the difficulties they may have in accessing documentation to support their applications, or because their carers may not understand the need for them to apply, or because local authorities may be overstretched and not able to give them the support that they need to do so. And as I've said, many will be reliant on legal aid to support them in making a sufficiently strong application. Social workers have neither the expertise nor training, nor the capacity, nor indeed the legal right to give advice in relation to immigration matters. They would be in breach of immigration law if they tried to do so. So it is absolutely vital that the Government, having after a year finally tabled the order to bring immigration cases for looked after children within the ambit of the Legal Aid Act, actually gets that order put through, and in good time before the 31st of October. And I hope the Minister will be able to commit today that the Government will ensure that that happens. I'd like to mention a couple of other points, Mr. Bone. First of all, turning to the issue of children's best interests. I recognise that the Children Act of 2004 requires that local authorities discharge their functions, having regard to the welfare of children, and I also recognise that Section 55 of the Borders, Citizenship and Immigration Act 2009 requires immigration authorities to take into account the need to safeguard and promote the welfare of children in the UK. But the lack of systems and processes to embed children's best interests into the settled status decision-making process means that they may not be properly addressed. So what guarantees can the Minister give us that the EU settled status scheme will operate so that children's best interests are always paramount? Will that be made explicit in the settled status scheme? And will she undertake to carry out a child rights impact assessment of the operation of the scheme? I too would like to highlight the particular concerns that exist in relation to EEA and Swiss national looked after children in the criminal justice system. As we've heard, looked after children are disproportionately represented in the criminal justice system. Half of children in custody have been in care. But as with local authorities, again, there is a dearth of data about the nationality and status of children in the criminal justice system. So will the government put in place arrangements to collect centrally nationality data for children in youth offending services and in detention as a matter of urgency, so that where applications need to be expedited for those children, that can take place? And as my honourable friend, the member for Selly-Oak, has said, our criminal justice system does recognise the difference between childhood and adult offending, for example, in sentencing or in the time that it takes for a conviction to become spent. But that difference isn't clearly recognised in the EU settled status scheme. Any child or young person over the age of criminal responsibility, in other words, over the age of 10, Mr. Bone, will be subject to criminality checks. And where checks reveal serious or persistent offending, a referral will be made to immigration enforcement for a case-by-case determination as to whether an applicant should be reviewed status on the basis of suitability. Now, I recognise that the government stated that those under the age of 18 will not be required to answer questions relating to suitability, and that children under 18 will only be deported on grounds of imperative public security. But there's no single definition of what kinds of offences are likely to be captured in that exception, and I think it would be really useful if ministers could guarantee to set out the higher threshold that will apply in guidance, and also confirm that both the non-disclosure requirements and that higher threshold applying to under 18s will again continue after the 31st of October, even in the event of no deal. The settled status scheme also fails to differentiate between adults and children in relation to the continuous residence criteria, in that the general caseworker guidance makes no distinction between adults and children in terms of resetting the clock on residence following a period of imprisonment or detention. So will the government look at amending the scheme to ensure that a custodial sentence imposed on a child doesn't impact on the calculation of their continuous residence for the purpose of making an application for settled status? Finally, may I invite the government to publish specific guidance on children and young people applying to the settled status scheme from within the secure estate or the wider criminal justice scheme? And would the government consider granting settled status to all children irrespective of their criminal history? Indeed, I echo the calls that I've heard elsewhere this morning in this chamber to invite the government to supply settled status to all looked after children and children in care. We risk those children being left in a limbo that will affect them all through their adult lives if we do not make absolutely clear and safe their status now. And as we've heard, those children have already demonstrated their right to our protection. We cannot afford to let them down as a result of a decision to leave the European Union, which was in no way any of their making.
Jim Shannon.
Thank you, Mr. Bowen. Can I first of all say it's a pleasure to follow the Honourable Lady, and thank you for her contribution. Special thanks to the Honourable Gentleman for East Worthing and Shoreham, and also to the Honourable Member for Birmingham Selly-Oak for setting the scene so well and for seeking to have the debate as well. Contributions of all has been excellent, and I want to congratulate them. Also nice to see the Minister in her place. The Minister has had a tour of many ministerial positions over the last while, and it's very pleased to see her in her position. Look forward to her response in relation to this. If her response follows the other portfolios that she's had the responsibility for, I believe we'll have a good response, and I look forward to that. I'm very happy to support this application and indeed this debate today. I spoke to the Honourable Member from Birmingham Selly beforehand, and I've been contacted by many people in relation to this, and specifically I want to mention, if I could, the Children's Society, who have some very real concerns that we must seek to address in this place, whether there is a deal, which I sincerely hope that there will be, or whether there isn't a deal, which is a Brexiteer, will not be a disappointment either. The fact is that we are leaving Europe, and we must do the businesses for those who looked after children, and we can't ignore that. So whatever everyone has said this, so it's important we do put it on record. Whether we're in or out of Europe, this issue has to be addressed, and that's the reason for this debate today. An email sent to me by the Children's Society expressed a very clear concern that I will read out now. The concern is over, and I quote them to what they said. The estimated 700,000 EU national children living in the UK are lost within the public debate about the EU settlement scheme. The quarterly immigration statistics show that only 12% of the applications to the EU settlement scheme received by the end of June 2019, just by there, came from children under 16, meaning that an estimated 600,000 EU national children still need to regularise their status before the deadline. Some of the background information that we were given would endorse that. The Migration Observatory report on settled status suggested there could be upwards of 661,000 non-Irish EU citizen children living in the UK. And they would say this indicates at least 500,000 children who could be eligible to apply to the EU settlement scheme are yet to make an application. So again, I would ask Minister what has been done to address quite clearly a figure that needs to be looked at in relation to those who have not applied, and how many of these children are in local authority care. For those are all parts of the questions as well. Among the European population will be thousands of children and young people who are currently looked after by local authorities. And whilst these children make up a fraction of the overall population, it is to this fraction I believe that we owe a special set of responsibility to. So I endorse what the Children's Society has said, very clear. There is a real concern that we are not meeting the obligations upon us for this admittedly small number of children, and that is the purpose today, to highlight this to the Minister and hopefully have a response that addresses some of the concerns that we have. Although I'm not sure that she is aware and her department is working on this. Perhaps maybe the Minister will indicate that that's to the contrary, but I'm anxious to hear how this has been taken care of and the detail that I am sure the Minister will be happy to outline in this response. Again, in the background information in relation to British citizenship, there have been some concerns raised that whilst it could be more advantageous for eligible looked after children to apply for British citizenship instead of settled status, they could be unaware of their rights or face difficulties paying the fee. The Honourable Gentleman for Birmingham Sally Oak referred to the £1,012 that it takes to register a child as a British citizen. Again, that figure. And under the present system as well, it's not clear how those who may automatically be British will be identified. There are likely to be significant numbers of European national children and young people who could fall under these nationality provisions, but who do not know their own rights. Minister, again, I look to you for a response on this. If looked after children are completing settlement scheme applications on their own and without legal advice, I hope they're not, but if they are, and it's quite possible that they are, they will also not be fully aware of their options. So it's to make sure that the applicants have all the help that they need to fill in for any incorrect grant of pre-settled status, being refused outright, or potentially missing another legal avenue available, such as applying for British citizenship. Again, Minister, I think it's so important that we address these issues, as we have said. I am, Minister, and members will know that, I'm a firm Brexiteer. I remain of that opinion, but that does not in any way diminish my sense of compassion or obligation that I have as an individual, or this Parliament should have. And whilst I do not agree with many parliamentary colleagues regarding the merits of staying in Europe, I do sincerely, very sincerely, agree that we must do what we can to ensure that those who need special status are able to access it, especially those who are children and not aware of what all of this Brexit talk actually means to them, because it may be lost upon them in the process. I have been informed that combined data from the four nations highlights that there are over 95,000 looked after children in the UK local authorities in 2017. I'm sure that figure has probably increased in the last couple of years. Again, while the government does not currently collect and publish data centrally on looked after children's nationality, only their ethnicity. A recent parliamentary response highlighted that the Home Office has estimated that there are some 5,000 EU children in care currently in the UK, not including the care leavers or children classified as in need. There are children that we must ensure that their social workers are crystal clear in the steps that must be taken to ensure their place here post the 31st of October. A very, very key role for social workers. And it's important, Minister, that the social workers are enabled to carry out their responsibility on behalf of those young people. Again, there's also no centrally collected and publicly available data on European national care leavers, although the government estimates that there are 4,000 care leavers to age 25 in scope, and I believe that steps could be taken to ensure that this group of people are also made aware of anything that they must do to ensure that they continue to remain post 31st of October. Can I just very quickly, Minister, and I'm coming to the end of my contribution, Mr. Bowen, ask again in relation to care leavers. The Honourable Gentleman for Birmingham Sally Oak referred to it in his introduction, and others have referred to it as well. And I just want to, again, figures for England, although these figures across the whole of the UK, of Great Britain and Northern Ireland, are clear that in the year ending the 31st of March 2018, local authorities were in touch with 88% of the 19 to 21-year-old care leavers. To be counted as in touch, they should be in contact between the local authority and the young person around 3 months before and 1 month after the young person's birthday. Local authorities, therefore, do not necessarily maintain contact with all care leavers, and it's possible that some will fall between the cracks. Can I ask, Minister, what has been done to make sure that those young people don't fall between the cracks? What's been done to address, say, 12% of those who have not been contacted? What's been done to make sure, I say these very, very, very honestly and respectively to you, Minister, what's been done to ensure that these young care leavers do not find themselves not having the opportunity to advance their applications? Again, I would ask the Minister, in a response to outline what the current situation is in relation to the questions that I've asked and others have asked, and if the Minister believes that more can reasonably be done to ensure that all of the people and the support is available for these vulnerable children and young adults. And my role, as I've always had in this House, for me it's important that those who need help get help. Those who need support get the support. And part of my responsibility as a Member of Parliament and as all here collectively in this House is to ensure that this issue is addressed, and we look to the Minister for that response. Thank you.
Stuart C. MacDonald.
Thank you very much, Mr Bowen. It's a pleasure to serve under your chairmanship. Can I also start by paying tribute to the honourable members for Birmingham, Selly Oak and East Worthing and Shoreham for pursuing this issue and securing the debate from the Backbench Business Committee. Let me also pay tribute to all honourable members who have contributed today. There was a tremendous range of expertise on show. Slightly surprised that no honourable member wanted to pay tribute to and thank our munificent Prime Minister for giving us humble MPs the opportunity to actually debate a Brexit issue today, because apparently that is something that we can't take for granted anymore, but perhaps that's an issue that we can address later on today in the main chamber. Can I also join other honourable members? I'll happily give way to my honourable colleague.
Confirm the number of hours that were given to the Scottish Parliament to discuss emergency legislation that was rushed through in Holyrood?
I don't know the answer to that question, I have to say, Mr Bowen, but I'm sure it was perfectly adequate for the...
Out of order.
Thank you very much indeed, Mr Bowen, for coming to my assistance. Can I also join honourable members in welcoming the Minister to her place? But I do also have to start with a slightly cheeky question, and that is she actually the Immigration Minister? Because we are at a time where we have this settlement scheme being rolled out, where huge reform of the immigration system is ahead, and we spent the summer not knowing actually who was responsible for immigration matters and where I should send my angry letters or indeed my very constructive and helpful letters. But if she is Immigration Minister, she can look forward to lots of correspondence in the weeks ahead. Anyway, Mr Bowen, turning to the issue at hand, other honourable members have eloquently and persuasively set out the significant challenges that looked after children and care leavers will face in accessing either the immigration status that is in their best interest, or alternatively the citizenship status that they are entitled to and will be in their best interests. I've also heard concerns about the underrepresentation of children amongst those who have already applied for settled status. On the settled status scheme in particular, as the Honourable Member for Birmingham Selly-Oak said, even with the Home Office pulling out all the stops, and I appreciate the Home Office is putting a lot of work and resource into this, almost certainly hundreds of thousands of EU citizens or their family members will not apply or achieve settled status or even pre-settled status by the deadline that has been put in place. For some, as we've heard, that will be because of lack of awareness or because of legal complexities, which mean people don't understand that they need to apply. And for others, as we've heard, there will be barriers in relation to the evidence that needs to be sent in. And looked after children, care leavers and other vulnerable persons will be overrepresented in these groups. And as with everyone else affected, the consequences of failing to apply in time will be dire. Overnight, they will be deemed to be in the country illegally, and the full weight of the hostile environment will kick in. University, education, some healthcare, bank accounts, driving licence, employment, social security will all be put out of reach. So what can we do to stop it? Mr. Bowen, from my party's point of view, the solution to all of this is to keep free movement of people, either by abandoning Brexit altogether or by securing a deal which includes retaining all the advantages of free movement. And I accept it would be a brave and surprising announcement from the new Minister if she was to accept that as a proposition. So if that is not possible, then the Prime Minister should do what he promised to do, and indeed the new Home Secretary and the Chancellor of the Duchy of Lancaster during the referendum campaign, and that was to enshrine the rights of EU citizens in law. In a declaratory system, EU nationals would not be required to apply to retain their right to live here. They would be granted that right in an Act of Parliament, but would simply apply to the settled status scheme for a document proving the position going forward. And Professor Smysons and the 3 million have worked extensively on proposals on how to do that, and the Home Office should engage with them. Now, I accept that that's not a perfect solution in itself because, of course, after the deadline, there would still be hundreds of thousands of people who wouldn't have applied for the necessary evidence of their settled or pre-settled status. However, the simple truth is that they would have the right to be here and would therefore still be able to provide proof of that right and to secure the necessary documents or other means of proof as soon as it became apparent to them that they required to do that. The Home Office's refusal to listen or to understand this simple fact is infuriating. And it's made various nonsensical arguments about declaratory systems being responsible for the Windrush fiasco. But that is not what a single inquiry into that horrible episode has determined. It's simply not true. Under a declaratory system, those who miss the deadline will have a chance to rectify their position. Under the Home Office system, as currently established, it will leave hundreds of thousands of people here without legal status, an absolute disaster. And thousands of them could very well end up being looked after children, care leavers and other vulnerable citizens. So I call for a declaratory system altogether. If that's not even possible, then absolutely I join colleagues in making sure that it's a declaratory system for looked after children and care leavers. So I hope the Home Office will think about changing path now. But in the meantime, can I ask the Minister, has she made, and has the Department made, any attempt at estimating how many people it expects will not apply before the deadline? And will she make clear today what will happen to those who miss the deadline, including looked after children and care leavers? How will they be treated? There's been an incredible lack of clarity on that score. And if the Home Office is not going to change tack, then we should be allowed as MPs to debate the issue and to vote on it. And we had debates on this issue during the passage of the immigration bill. So I'd also like to ask the Minister what has happened to that bill and what is going to happen to it now. Now, regardless of whether the Home Office chooses to change tack on this fundamental approach, or more likely it's forced to by way of legislation, or whether it presses ahead with its current model, there are other issues that members have raised today that need to be addressed and actions pursued. Home Office must ensure that there is sufficient funding for awareness-raising programmes, with a particular focus on making sure local authorities have a clear understanding of what is required of them in relation to looked after children and care leavers, and the resources to ensure that these groups are able to access all the advice and support that they need. The position of many of these youngsters, as has been said, will be incredibly complicated, and choosing the right application to make, or whether to make any application at all, or whether the child may actually have a right to citizenship, these are all hugely complicated issues, but issues that have profound implications for them. And we can't expect social workers to be doing all of that. All of these young people must have access to specialist legal advice and support, and that should be funded by the Home Office. The duty of local authorities must be to do everything possible to secure that expert advice and not to provide makeshift alternative advice themselves that they are not qualified to deliver. And as other members have said, the duty must extend to all looked after children and care leavers, not just those that local authorities have parental responsibility for. I echo the comments of the Honourable Member for Stretford and Urmston in relation to legal aid. The change announced in July 2018 of the reintroduction of legal aid for separated children with immigration issues, including children who will need advice and support to secure EU settled status or understand the right to British citizenship, is yet to be implemented, and it's essential that we know what's going to happen to that proposed change, given that Parliament may not be sitting very much longer. And more broadly, I would say immigration and citizenship should be generally brought within scope for legal aid, as it is in Scotland. But finally, let me turn to the distinct issue of citizenship, which is also going to be relevant to many care leavers and looked after children, because among them will be a significant number entitled to register as British citizens. The key barriers are, yes, again, lack of awareness, but also the extortionate cost of vindicating those rights via the registration process, as other honourable members have said. So as well as, again, repeating measures to ensure access to legal advice, we also need to address the outrageous fees being charged by the Home Office. The new Chancellor, when he was Home Secretary, acknowledged that the £1,000 fee was a huge sum of money to charge children. I'd say it's disgraceful, particularly when we're talking about looked after children and care leavers. These kids are, at the end of the day, as entitled to citizenship every bit as anybody in this room. They should not be prevented from accessing it by extraordinary fees. And I urge the Minister not to do what other immigration ministers have done previously, and that is to conflate this issue either with migration fees or with adult naturalisation processes. They are completely different things. We are talking about a group of children that Parliament expressly protected the rights of citizenship for when ending the general provision of citizenship by birth in 1981. I mean, if Home Office officials demanded £1,000 from every mother leaving the maternity wards in order to secure their kids' citizenship, there would quite rightly be outrage, Mr Bone. Charging these kids for theirs is just as morally reprehensible. So at least in the case of looked after children and care leavers, surely the Home Office must see how outrageous its position has been up until this point and act accordingly. So once again, Mr Bone, in conclusion, I congratulate honourable members for securing this debate. I support them in what they're trying to achieve, and will very happily work with them in the future in attempting to persuade the Home Office to listen.
Shadow Minister.
It's a pleasure to serve under your chairmanship, Mr Bone. Can I also congratulate the Minister for her post and look forward to working constructively with the Minister. Can I thank my honourable friend, the member for Birmingham Surrey Oak, for securing this important debate and bringing this serious issue to the fore. I also want to thank the Children's Society, the Refugee and Migrant Children's Consortium, and the Greater Manchester Immigration Aid Unit for their comprehensive briefings ahead of this debate. As we head ever closer towards a disaster no-deal Brexit, the rights of 3.8 million EU nationals living in the UK are still in jeopardy. By a conservative estimate, there are 5,000 EU children currently living in care in the UK, and a further 4,000 care leavers who will be affected by the EU settlement scheme. Across the UK, our already stretched local authorities are now responsible for safeguarding the rights of thousands of European looked-after children and care leavers. If this already vulnerable group of children does not secure their rights after Brexit, we could very easily double the number of undocumented children living in the UK. I'm sure the Minister will agree this is not a situation any of us want to see. These undocumented children and young people would then be subjected to all of the government's hostile environment policies. They will be unable to work, to drive, or to open a bank account, and they will effectively be barred from college, university, and secondary health care. This is why Labour supports a declaratory scheme as opposed to government's constitutive scheme. A declaratory scheme would ensure all EU citizens living in the UK would automatically retain their rights after Brexit. This is an issue I had many discussions with the previous minister about, and I hope the new ministerial team will look again at this proposal. Without reforming the system entirely, it is imperative that the government look again at the problems faced by children in care and care leavers in applying for settled status. I will now outline the three most pressing concerns I have. I think a number of the other members have also touched on some of these, about the children in local authority care and care leavers who need to secure a settled status. First, many looked after children and care leavers lack the documentation necessary to complete their application under the settlement scheme. Many children in care will not have the identity documents the Home Office requires for settled status. If a child is born in the UK, they will more than likely not to have a passport identity card to prove their nationality. It is estimated that over 500,000 children fall into this category. As the largest scale registration program the Home Office has ever embarked on, the settlement scheme has brought into stark relief how little we know about the immigration status of the children in the care of the state. Does the Minister agree that we must ensure these children do not fall through the gaps just because they are unable to prove their nationality? My second concern is the lack of information available to local authorities. The government has spent the last 10 years slashing local authority budgets, and now they expect these cash-strapped councils to take responsibility for registering the thousands of EU national children in their care. Earlier in the year, following the rollout of the settlement scheme, the government issued guidance to all local authorities on how they should be supporting children in their care and care leavers. This guidance stated there is no general duty on local authorities to ensure that immigration status is secured for looked after children. Would the Minister not consider securing a looked after child's immigration status to be fundamental to the state's corporate parenting responsibilities? Thirdly, I would like to raise my concern about the legal advice being offered to looked after children. There is a potential for children with the rights to apply for British citizenship being advised to pursue settled status in the rush to ensure they are protected. Does the Minister agree that only those with sufficient expertise should be giving immigration advice to children in care and care leavers? All look-after children have the rights to seek legal aid in applying for their settled status. What steps is the Minister taking to make local authorities aware of their rights to apply for exceptional immigration case funding for children in their care? And will the Minister also guarantee parliamentary time in what remains of this session for the amendment to the Legal Aid Sentencing and Punishment of Offenders Act 2012 that would cement the rights in legislation? Labour is committed to providing early legal advice for all immigration cases. We understand that legal aid is not just a force for good, but could also save the tragedy millions in for the long run. As we all know, there are a multitude of problems at every stage. Save the tragedy millions in for the long run. As we all know, there are a multitude of problems at every stage in the immigration process for children in the time it takes to apply and the hostile environment. I know there are many issues that I have not had time to touch upon in my speech today, but I hope the Minister will at least answer the questions I and colleagues have raised in this debate. It is vital that no vulnerable child or young person is allowed to fall through the gaps of the settled status scheme.
Thank you, Mr Bone, and it's a pleasure to serve under your chairmanship. I want to begin by thanking the Honourable Gentleman for Birmingham Selly, my honourable friend, the gentleman for East Worthing and Shoreham, and the honourable member for Cumbernauld, Kilsyth and Kirkintilloch for securing this extremely important debate today on the EU settlement scheme and looked after children and care leavers. The co-chairs of the APP are great champions for children, and it's right that we are discussing this today. Now, in terms of the EU settlement scheme, what it's designed to do is to deliver on the government's aim that EU citizens can obtain their status quickly and easily. The idea, the principle behind it, is that there should be a presumption of granting status. And the Prime Minister has made it clear that EU citizens living in this country will have the absolute certainty of the right to live and remain. And to the point that's been made by honourable and right honourable members today, ensuring that those who are most vulnerable, such as looked after children, are supported to obtain status has always been and continues to be a core element in the delivery of the scheme. And I want to ensure all members who've spoken today and those who have now left their places that this is a cross-departmental departmental priority for government. My department has engaged widely, including with DFE, with the LGA, where my predecessor spoke at the conference and addressed this point, speaking to the Association of Directors of Children's Services and as well as their equivalents in the devolved administrations in Northern Ireland, to understand and address the needs of looked after children and care leavers, ensure that they are supported. Guidance has been issued regarding their role and responsibilities for making or supporting applications for looked after children. Now, the scheme was first rolled out in the spring of this year, and we have had 1 million people who have been granted their status already. That was just in August. And if we're in a deal situation, this will be open until the middle of 2021. And if we're in a no-deal situation, that will be, people will have up until the end of next year, the 31st of December next year, to apply. Now, members have quite rightly raised a lot of points which touch on the scheme in general and also on the specific cohort of children, which I understand quite rightly as the Honourable Gentleman, who has great experience in this place and before, of the different strata of children that we're talking about. Just on the issue of the declaratory system, this has been designed in order to make sure that one of my successors standing here in 40 years' time doesn't have a system where people don't have their status, which is why there is the status of registration. So people who, EU citizens, particularly children and vulnerable who've built their lives in this country. Can I just finish this point, and then I'll quite happily give way to either an angry or a helpful comment. EU citizens, particularly children and vulnerable, who've built their lives in this country, have difficulty evidencing their rights to live and work here, and that speaks to the point that the Honourable Lady mentioned.
Grateful she spoke about her successor in a few years' time being able to say everyone has status, but only a declaratory system will do that. If we don't have a declaratory system, then inevitably there will be tens, almost certainly hundreds of thousands of EU citizens, including vulnerable people who do not have status. Does she accept that fact? Has the Home Office actually come up with an estimate of how many people it expects not to go through this process in time?
I'm afraid that I profoundly disagree with that point because this is actually ensuring that those citizens who are here, EU citizens, will have their settled status by obtaining, by going through this registration scheme. And if not, then there will be differences because people won't necessarily be able to prove where they were here at the point. But I want to focus specifically on this cohort of children and care leavers that we're talking about. Now, quite rightly, honourable members have referred to the fact that many of the children that we're talking about, because of the life situations they've had, do not have the same documentation that most of us in this room will have. We share those concerns. They might have no identity document because they might have had a complex or chaotic lives. And it's absolutely right that local authorities and health and social care trusts in Northern Ireland should obtain necessary identity documents for a child in care to ensure that, therefore, that they have uninterrupted access to services. But the Home Office guidance on this scheme has made it clear that applicants can apply without an identity document because they might be unable to apply because of their family circumstances. And as far as I'm aware, local authorities vouching for the fact can be adequate documentation for that. So,
give way on that point. I thank the Minister for giving way. As I said, one of the critical lessons from the pilot schemes that, like my local authority had, was the difficulty in getting hold of this documentation because embassies in other countries want parents to be involved. And it does come down to a very simple question for all of us, is do we want social workers to be chasing up embassies and parents or working with these kids? Is she guaranteeing now that if, say, my local authority simply said, yes, this child, we believe, is an EU citizen and therefore should be entitled to status in this country, that will be enough? Because if she's not, she is asking those social workers who don't have that legal background to go chasing this information that they cannot get hold of, not because of rules in this country, but because of rules in other countries. And that does risk these children not getting the status they urgently need.
Well, I think we need to be very careful because there's two issues. May I please finish my point? So the point is, some of the children we're talking about have the local authority is the parent. There's a second group that might be the parent, so the Section 20 children, and then there's other groups in which there are children in need. And the problem is, of course, that some children still have their parents who perhaps in a later point might come back in order to make the application for them. I know she doesn't seem, but we're talking about 3 distinct groups of children, and I think it's very important that we recognise that for some children, although they may be under temporarily a Section 20 order, then they may return to their parents afterwards. I must finish this point before I go on. But on the specific point she raises about can the local authority basically give the evidence, I have asked officials to look at it, and I will write to her in more detail on it. Okay. But I think it is important that not all the children we're talking about have local authorities who are sort of in loco parentis. Just on the role of local authorities. Now, there has been a new burdens assessment made. It will take into account the work that is very important work to identify the cohort of children and their parents. And we have asked local authorities to return figures by the end of August. I think the Honourable Lady for Stretford Urmston was referring to that, and we are currently coordinating these returns. Of course, that was only a few days ago that came in. So that's in terms of supporting local authorities. We have given £9 million to 57 voluntary and community sector organisations across the country to help us reach an estimated 200,000 vulnerable or at-risk EU citizens to help them apply. Because, of course, it's not only children who might be in a vulnerable cohort, and the Home Office is very aware of that. So additional support is available to those who don't have appropriate access, skills or confidence to apply online. There are more than 300 assisted digital locations across the UK, and in some certain limited circumstances there is an opportunity for a paper application as well. Yes.
Given away against being very generous with our time. Charities are telling us that they do not have the resources to do all the work that is required. Has she put in a request with the new Chancellor for additional funding so that we can absolutely leave no stone unturned in making sure we reach every vulnerable person in this country that needs to apply?
The scheme isn't designed that it needs a lawyer or legal advice. It is a simple scheme to use. I recognise that in some of the cases where we're talking about vulnerable and certain perhaps non-EEA dependents of EU, that there might be some complications. But the fact that over a third of the eligible people have already signed up in 6 months, I think is testament to the fact that it is designed to be a simple system. Yes, and then I will just carry on.
I'm very grateful. She may be right in saying that her intention is that the overall scheme was designed not to include great legal expertise, but the evidence of the quorum pilot is exactly what was required for the group of children this debate is about. Surely that's the point she needs to address.
Well, in terms of the quorum report and in terms of the contacts that the department is having with all those very important groups that are assisting vulnerable people, there are the guidance has been published, and of course, most importantly, guidance is being refreshed, and this debate is part of that to make sure that it's relevant. There has been a series of teleconferences for social workers and local authority staff, and they will continue monthly until next March. There's a designated telephone number for local authorities to call Settlement Resolution Centre. I want to touch on the very important issue that the Honourable Lady mentioned about legal aid. And she has quite rightly mentioned the fact that the order is here and hasn't been debated, and I'm going to contact and speak very urgently to my colleagues in the Ministry of Justice to bring that. But of course, up until then, applicants can apply through the exceptional case funding scheme.
I thank my honourable friend for giving way. I know she's making earnest promises about making sure that local governments will be worked with to make sure no child is left behind. Can she assure me and other colleagues that her department will work with the devolved administrations and local authorities in Scotland to make sure all children are cared for, and that certainly the same opportunities that are provided to those in England are provided elsewhere in the UK?
Well, I'm very committed to working with my counterparts in the devolved administrations, and I think it's testament to the importance of this debate that we have members here from, well, not the Welsh, unfortunately, but we do have members from all four nations, showing how we feel very strongly about protecting vulnerable children in this situation. Colleagues raised what would happen if children have failed to make an application by the deadline, which, as I said, is either end of December next year in a no-deal situation or summer of 2021 under the withdrawal agreement. And the government does have a special responsibility for these children and care leavers. I'm confident that with these measures in place, we will ensure that they secure a permanent status under the scheme. I want to touch on citizenship fees because all honourable members who've spoken have talked about that. Now, settled status does give indefinite leave to remain in the UK, but of course some countries don't allow dual citizenship. It is a personal choice. Citizenship is not mandatory. However, we have committed to reviewing fees for child registration applications, and we will keep the House updated on that. Just on the issue of asylum, which I think it was the honourable lady raised, or maybe it was my honourable friend, the UK does take its responsibilities towards unaccompanied children extremely seriously, and as my honourable friend mentioned, those numbers have been increasing. In the last 12 months, we gave protection to over 7,000 children. And whether we have a deal or not, cooperation with EU countries will continue on asylum. And that's why we've taken proactive action to ensure that whatever the circumstances, doubling requests relating to family reunification that have not been resolved on the date we leave will continue to be considered under existing rules. Touching quickly on the issue of criminality thresholds, I also queried the why there was a 16 and 18 gap. Now, applicants under 18 are not asked about criminality, but a PNC check is still conducted if they're only aged over 10, and only serious criminality, which falls consideration of deportation, is taken into account. Serious persistent offenders with extended custodial sentences. Now, I think this has been very, very important. I think that highlighting it at this early-ish stage of the EU settlement scheme is very pertinent. I want to thank the honourable gentleman for bringing it. We will continue to engage with relevant stakeholders to understand and address the needs of looked after children in care. I can reassure the House that this government is absolutely committed to ensure that we look after children and care leavers, and that all of such are supported to obtain their status under the EU settlement scheme.
Stephen King. To wind up.
Mr Bowen, can I just thank everyone who's taken part in the debate, and I do thank the Minister for her comments. I hope she will appreciate, as I said at the outset, this is a cross-party matter, and the people who are raising this here today are not raising it particularly because of their views on Brexit. We are raising it because of our views on the risk to this particular group of children, and it's that I would ask her to focus on. And while I recognise that the intention is not to make the scheme complicated, I'd really implore her to look again at some of the legal complexities that local authorities are raising and that look as if they're going to adversely impact on her good intentions.
The question is that this House has considered the EU Settlement Scheme and looked after children and care leavers. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order, order. We now move to another important debate. Mr. Philip Hollowbone to move the motion.
Mr Bone, I beg to move that this House has considered the proposals for an urgent care hub at Kettering General Hospital. And may I say what an unexpected pleasure it is to see you, Mr Bone, in the chair, and I'm sure we'll all benefit from your wise guidance and counsel. Could I thank Mr Speaker for granting me this debate, and may I welcome the Minister to his place to listen to the debate and to respond in the second half. Can I say at the outset, Mr Bone, that we're joined today by Mr Simon Weldon, who's the Chief Executive of Kettering General Hospital, an outstanding Chief Executive at our very popular local hospital, and you, of course, will know him as well, Mr Bone, as I do. Mr Bone, can I say that Kettering General Hospital is an extremely popular and well-liked local hospital. It's 122 years old this year and still occupies the site that it first occupied in 1897. There can't be many hospitals in the country which are still based almost entirely on their original location over a century before. But what we're talking about today, Mr Bone, is the urgent need for an urgent care hub on the Kettering General Hospital site. And the reason that we need this urgent care hub is because Kettering General Hospital is such a popular hospital that it simply can't cope with the numbers coming into the A&E at the moment. And everyone agrees, all the local NHS professionals in every NHS organisation in Northamptonshire, everyone agrees that what the hospital needs and the best solution to the challenges it faces is £49 million for the development of an urgent care hub on the Kettering General Hospital site. Now, the idea of an urgent care hub is that it would be basically a one-stop shop for GP services and out-of-hours care, an on-site pharmacy, a minor injuries unit, facilities for social services and mental health care, access to community care services for the frail elderly, and a replacement for our A&E department. And the most crucial aspect of this is the A&E department, which was built in 1994. That's 25 years ago. And when it was built to cope with 40,000 A&E attendances each year. Last year, in 2018, 91,200 patients came through that very same A&E. And this year, 2019, we're on track to go through the 100,000 patient attendances mark. This is well over 150% above its capacity. By 2045, 170,000 attendances are expected at the same site. I'll be delighted.
Thank you for giving way. When it comes to A&Es, it's just not the Kettering Hospital, which is the purpose of this debate, is A&Es across many constituencies are suffering similar problems. Does the Honourable Gentleman agree that we would all benefit in the A&Es and in the Kettering Hospital in particular, for this debate is about, from greater patient care and also a better working environment for the health professionals? Because whenever it comes to having the hospital and the A&E in place, it's also important to have health professionals who are happy at their work and feel that they can move forward. And what is possibly the most stressful speciality, and at the long run, this investment he refers to will pay for itself in better patient outcome and better staffing capacity.
That unexpected contribution from Northern Ireland, and it's always a delight to see the Honourable Gentleman in his place and thank him for his support. And I do agree, there's pressure on A&E facilities across the country. Of course there is. I think the case that I'm making for Kettering is that it's particularly acute in Kettering, not least because of the number of houses being built locally, the increase in the local population, and the fact that, thank goodness, we're all living longer. But in Northamptonshire, there's a particular increase in the number of elderly patients who are being served by the local hospital. But I thank him for attending today and for his support. Now, in 2016, 3 years ago, Dr. Kevin Reynard of the National NHS Emergency Care Improvement Programme visited Kettering's A&E, and he concluded, and I quote, "The current emergency department is the most cramped and limiting emergency department I've ever come across in the UK, USA, Australia, or India. I cannot see how the team, irrespective of crowding, can deliver a safe, modern emergency medicine service within the current footprint." And indeed, Simon Weldon himself is extremely concerned about patient safety, and he's said to me that sooner or later there will be a patient death in Kettering's A&E unless we get the situation sorted. Now, the impacts of the incredibly cramped department result in staff not having clear lines of sight on some of the most unwell patients to ensure they are monitoring their conditions appropriately. Privacy and dignity for patients is not able to be maintained due to overcrowding and cramped spaces. Patients are waiting longer than the national limits as there is physically not enough space to treat the volumes coming in the door. Children having to wait openly in corridors they have to go through adult areas to receive treatment. There's a lack of space to offload ambulances, often resulting in long queues, inhibiting ambulance response times to 999 calls. The rooms in the A&E do not comply with many current health building standards, and there is a lack of natural daylight. The CQC itself and other inspections have consistently raised multiple concerns for both adult and paediatric patients regarding the size and limitations of the estate. And most importantly, the volume of patients, as I've described, has reached a critical point, and patient safety is now needing to be managed by staff on a daily, patient-by-patient basis. For health professionals who take a pride in their job, the challenges of working in Kettering A&E are becoming unbearable. Now, the future situation is that local population growth for the next 10 years is planned to far exceed the national average, and our catchment includes the fastest growing borough outside of London in our neighbouring constituency, Mr Bone, of Corby. Indeed, at the last census, Kettering was 6th out of 348 districts in the whole country for growth in the number of households, and 31st out of 348 for population increase. In Corby, they have the highest birth rate in the whole country. Our local area, Mr Bone, has been included as part of the Cambridge, Milton Keynes, Oxford corridor, and in this corridor there is a commitment to build 35,000 new homes in the next 10 years. Kettering Hospital is expecting a 21% increase in our over 80-year-olds and 10,000 more A&E attendances in the next 5 years alone. Now, despite some temporary modifications over recent years, including moving other patient services off the hospital site to accommodate delivering safe emergency care, detailed surveys have shown there now remains no further opportunities to extend the current department, and a new building on the site is required. Now, following all these safety reviews and surveys, the hospital has developed a business case for a fit-for-purpose emergency care facility that will meet local population growth for the next 30 years. It's been developed with all the local health and social care partners across Northamptonshire so that patients can get a local urgent care service that meets all government guidance on good practice, ensures they get the care they need to keep them safely outside of hospital, and ensures they are cared for by the right clinician at the right time, first time. The Central Care Hub would be a central cog in a whole system approach to delivering urgent care services to meet the needs of our local population, and it will work alongside GPs, mental health, community and social care services. Now, the hub continues to be identified as the highest clinical safety priority across the whole of Northamptonshire by the Northamptonshire STP. It was also approved by NHS Improvement Midlands and East Regional Team as the highest priority submission for central capital funding. What we're talking here about, Mr Bone, is £49 million. And of all the 44 SDP areas in the country, Northamptonshire is the only one not to have received any capital funding at all in the last 4 waves of capital funding coming from the department. And I would like to ask the Minister why that is the case. And if he were to agree to this urgent care hub proposal, that would put that wrong right. Now, the Trust can only access £3.5 million annual capital derived through its own funding. And as a county in Northamptonshire, only £20 million is available. But this is used simply for maintaining essential equipment and repairing heating and lighting systems. Kettering General Hospital therefore requires central funding or some form of private financing to build this facility. Despite a bid being submitted as the highest clinical priority for funding across the whole of the NHS in Northamptonshire and by NHS Improvement regionally, recent government capital allocation announcements in the last few weeks have not included the urgent care hub, nor any other monies for Northamptonshire or our local region. I simply don't understand, Mr Bone, why Kettering General Hospital has been missed off the list. Now, the national NHS Improvement team have indicated there will be no further announcements on SDP capital funding until spring 2020. But I do understand that the government is now reviewing all spending allocations across all departments with the comprehensive spending review, which is expected later this week. Local people will be very, very surprised indeed if Kettering General Hospital isn't included somewhere in that comprehensive spending review. So can I ask the Minister, with the clear patient safety concerns recognised at Kettering locally, regionally and nationally by NHS experts, what process did the government follow in awarding the central NHS capital allocations to schemes in the recent weeks, and why was Kettering not included? Why were some of those awards made to areas with no apparent clear and worked up business cases, whereas Kettering does have a clear and worked up business case? With a lack of access for further NHS capital funding, what are the alternatives for Kettering General Hospital unless there is a central grant of funding from the Department of Health? And how are the government correlating healthcare decisions with the locations of planned growth in housing? Now, Mr Bone, I do my humble best as the local elected representative to raise these concerns. The Chief Executive of the hospital, Simon Weldon, would have made a far better job of this debate than I. But can I also quote from some of the dedicated healthcare professionals in our local hospital who perhaps can outline the challenges they face far better than anyone else. The head of children's safeguarding at the hospital, Tabi Tantawi Basra, said, "Children have to wait in corridors alongside seriously unwell, drunk or mentally unwell adults. This causes a serious safeguarding concern as our staff are not always able to have line of sight on them." Sarah Parry, who's a nurse for end-of-life care at the hospital, said, "When a patient is brought into A&E dying or already passed away, there is no space where relatives can sit quietly to receive the news and grieve. We can't even make them a cup of tea. They have to share a facility with the staff room." Jackie Barker, who's the head of adult safeguarding, has said, "We know from the Winterbourne Views scandal that the lack of privacy and dignity for vulnerable adults seriously impacts their mental well-being. Sadly, our facilities mean even our most vulnerable adults are looked after in very cramped conditions, sometimes next to disruptive or aggressive other adult patients." Claire Beattie, who's the head of nursing medicine at the hospital, said, "Our staff work tirelessly to keep patients safe under the most difficult of conditions. The way the treatment areas are configured means they struggle to easily communicate or ask for help. And if patients are deteriorating, then it isn't always easy to see that quickly and give the urgent help they need." Leanne Hackshaw, who's the Director of Nursing, said, "Patients are so close together they can almost hold hands. And if someone is being sick or coughing badly in the next space, then every other patient worries about who they are so close to." Polly Grimmett, who's the Director of Strategy, said, As director on call in August, we had over 100 patients in the department for most of the night, and it's only safely meant to fit 40. There were 10 ambulances with patients queuing. This is meant to be our quietest month, so who knows how bad it will be in December. And Nicola Briggs, who's the Director of Finance, said, if we stopped spending any money at all on necessary things like replacing light bulbs or fixing equipment, then it would still take us nearly 15 years to save up enough money ourselves. Mr. Bone, the Urgent Care Hub is, as far as I'm concerned, the #1 priority for local people in Kettering. Kettering General Hospital is a much-loved local hospital. We need more investment to cope with the growth in the local population and to care for our increasingly aged population. I would like to invite the Minister to visit the hospital and see the A&E department for himself. If he does so, he'll follow in the footsteps of 2 previous hospital ministers and the previous Secretary of State. These problems are well known in the Department of Health, and I simply don't understand why £49 million, which in contrast to the size of the whole NHS budget really isn't very much, cannot be allocated to fund this badly needed urgent care hub at Kettering General Hospital. All the local NHS agree that this is the answer to the difficulties and the challenges that the hospital is facing. Now, more patients are now being treated at Kettering General Hospital than ever before. They are being treated with increasingly world-class treatments. And I would like to thank all the dedicated local NHS professionals who work in our local hospital for the magnificent work that they do. In order to help them face the challenges ahead, we urgently need £49 million from the government for this badly needed urgent care hub facility. Thank you.
This House has considered the urgent care hub at Kettering General Hospital. Minister.
Thank you, Mr. Bone. It is an honour to serve under your chairmanship in what is my first debate as the new Minister of State for Health. And I'd like to start by congratulating my honourable friend for Kettering for securing this debate about the urgent care hub, the proposed urgent care hub at Kettering General Hospital. I know this is an important issue, not only for my honourable friend, but also his constituents and the wider Kettering community, and it's one that I understand he campaigns tirelessly upon, and I congratulate him on his diligence and determination to continue that campaign and bring that debate to the House today. The Kettering General Hospital, as my honourable friends mentioned, stood on the same site for nearly 122 years and does play that vital role in the community. And my honourable friend has set out very eloquently the importance of the hospital for the community. I know that my predecessor, the honourable member for Wimbledon, discussed this proposal for the urgent care hub at Kettering General Hospital with the honourable member and visited the hospital in January of this year. Following the hospital's Foundation Trust unsuccessful £45.7 million Sustainability and Transformation Partnership bid in July 2018. And the honourable member has set out very clearly the need to be able to cope with rising demand, which he believes that this urgent care hub will be able to assist with. I'm sure my honourable friend is aware, as a result of the unsuccessful bid, that the Sustainability and Transformation Partnership Programme has been, to date, the main funding route for strategic capital development projects. And under this programme, capital has been allocated to over currently 170 sustainability and transformation partnership schemes since July 2017, and that now amounts to roughly around £3.3 billion. The Sustainability and Transformation Partnership, STP, investments will modernise and transform the NHS buildings and services across the country, including new urgent care centres, integrated care hubs that bring together primary and community services, and investing in new mental health facilities. And on the 5th of August this year, the government announced a £1.8 billion increase to NHS capital spending on top of the additional £3.9 billion announced in the 2017 spring and autumn budgets. £1 billion of the increase to the NHS capital spending will allow existing upgrade programmes to proceed to tackle the most urgent infrastructure projects, and 850 million of funding to allow 20 new hospital upgrades to start as soon as possible. These 20 hospital upgrades were chosen because they applied for funding at the Tranche 4 of Sustainability Transformation Partnerships, but had just narrowly missed out in the Wave 4 announcements. And in terms of ensuring that we look at this process going forwards, I actually wanted to set out this actual process that we go through by which the waves have been designated and the 20 hospital upgrades narrowly missed out previously but received funding this time around. Yeah, certainly.
Narrowly missed out on previous allocation of funding. And Northamptonshire is the only one of the 44 STPs in the country which has never received any capital funding in the 4 waves of capital funding that have taken place. Now, I find this staggering, given the overwhelming support from the NHS locally for the urgent care hub proposals.
Minister. Well, I think in terms of the assessment and the process that is taken forward independently by NHS Improvement and NHS England, it's important that when we look at how these waves have been assessed in the past and how the 20 hospital upgrades were now announced, taken forwards just last month, they were assessed on the following criteria. There were 6 criteria in total: deliverability, patient benefit and demand management, service need and transformation, financial sustainability that delivers savings, both the organisation and also the Sustainability and Transformation Partnership, value for money, including return on investment, and estates. And on top of those top scoring schemes, a number of the schemes have been included of critical service importance, drawing on the advice from Sustainability and Transformation Partnerships, national and regional NHS leadership, including mental health, learning disability schemes, together demonstrating they'll deliver clear improvements to clear services. And I know that's not necessarily the answer he wants to hear at this particular moment, but I wanted to reassure my honourable friend that I'm happy for NHS England and NHS Improvements to be able to discuss in greater detail this process and how the requirements operate when it comes to the scoring process. And indeed, the Chief Executive, Simon Weldon, who is listening to this debate today, if the Trust would like to be able to have that meeting, I would happily help liaise and arrange for that feedback to be received for the hospital and indeed the honourable member. Now, turning more generally to future capital funding, as I've said, already we have had the extra £1.8 billion announced in August. This was money that was not previously available to enable investments in critical infrastructure. It's new spending power, money available to the NHS that they couldn't spend before to fund new projects. The £1.8 billion is a brand